Hi, Mark Pelley here, Registered Migration Agent at Visas to Australia. We are a leading migration agency based in Melbourne with a remote office in Diamond Creek. Today we're going to be discussing the Subclass 802 Child Visa, which is to be applied for when you're onshore here in Australia. This visa currently costs $2,665 at the time of making this video. It is a permanent visa allowing the child to remain in Australia to stay with their parents. This visa is suitable for biological, step or adopted children of Australian citizens, permanent residents or eligible New Zealand citizens. These children need to be onshore at the time of applying for the visa as well as when a decision is made by the department. The Subclass 802 Child Visa allows your child to remain onshore as a permanent resident here in Australia. As such, they will be entitled to Medicare, to study and remain in Australia to live with their parent. They will also be entitled to sponsor relatives and of course apply for Australian citizenship if eligible. To be eligible for the Child Visa Subclass 802 onshore application, you would need to be a dependent child of a parent who is an Australian citizen, permanent resident or eligible New Zealand citizen. The applicant, as in the child, needs to either be a biological child, stepchild or adopted child of the parent. They will need to be single and dependent on the parent and of course in Australia at the time the application is made and when a decision is made by the department. If your child is a stepchild, then the stepchild must be under the age of 18 years of age and must be the child of the step-parent's former partner. The step-parent must also have an Australian parenting order in force to say that the child can live with the step-parent, or the step-parent must have guardianship and custody of the child in accordance with the laws of Australia or their home country. If your child is adopted, then the adoption needs to be finalised before the child turns 18 in order to be eligible for the Subclass 802 Child Visa applied onshore. The adoption could have happened either before or after the parent became an Australian citizen, permanent resident or eligible New Zealand citizen. If the child was adopted after the parent became an Australian citizen, permanent resident or eligible New Zealand citizen, then the adoption must have occurred either through one of these means. The first way to do this is through an inter-country adoption where an Australian state or Central Territory Authority was involved. Alternatively, through inter-country adoption, where both countries are parties to the Hague Convention, or if no Australian state or territory was involved, then the parent needs to be able to demonstrate that they resided for more than 12 months outside of Australia prior to the adoption, and that they did not do so for the purpose of adoption as well. It is strongly recommended for parents with adopted children that you seek both legal advice here in Australia as well as the child's home country to make sure that you abide by all relevant laws. The child must be sponsored by an eligible parent or the parent's partner. This sponsorship needs to be approved by the department as well. The department may not consider the sponsorship eligible if the sponsoring parent or the parent's partner has been found guilty or charged with crimes involving children. The child must either be under 18 years old, aged between 18 to 25 and studying full-time, or alternatively over 18 and with a permanent disability. If the child is aged between 18 and 25 and studying full-time, then they must be financially dependent upon the parents, they must be studying full-time when the application is made and when the application is decided, and of course they cannot work full-time. The child is considered to be studying full-time if they are a full-time student and studying towards a professional, trade or vocational qualification. They must also be attending all their classes. If the child is over 18 and has a disability, then this disability needs to either be a physical or mental disability such that they cannot work full-time. The child must have no partner and they can never have been married or engaged to be married or in a de facto relationship at any point in their life. The child and any dependents who apply with them must meet all health and character requirements. I discuss health requirements in a separate video, but essentially this means you do not have any health risks that can pose a risk to Australian public health, including HIV, Ebola, polio, yellow fever, and diseases such as this. If the child is over 16 years of age, then they must meet the character requirements. The department may also ask that other family members meet the character requirements also. The child must also have no outstanding debts to the Australian government and, if over the age of 18, must sign the Australian Value Statement. The child might not be eligible for this visa if the department has cancelled or refused the visa since they have arrived in Australia. The child must have consent to migrate to Australia, and this is one of the most important points about the Child Visa Subclass 802 applied for onshore. The child must have the consent of all relevant parties so that they can migrate to Australia. The department will only grant a visa if all relevant persons who have any legal say over the child provide written consent to the department for the child to migrate to Australia. Also, the laws of the home country must allow the child to leave, and, if possible, the child migrating to Australia should be consistent with an Australian parenting order. Overall, it must be in the best interest of the child to come to Australia. If the child is under 18 and the department deems it's not in the best interest of the child to migrate here, then the visa can be refused. The Subclass 802 Child Visa is applied for onshore. This is a permanent visa that allows this child to stay in Australia indefinitely. They can travel to and from Australia for up to 5 years. If they wish to leave Australia after the 5-year period, then on returning they need to consider a resident return visa, or alternatively, if eligible, apply for Australian citizenship. If the child has siblings who want to apply, then each child individually needs to apply for their own child visa. If the child themselves has their own dependents, such as their own children, then these dependents can be placed onto the child visa in the application. The Child Visa Subclass 808 is an onshore permanent visa. It costs thousands of dollars to apply for, and this is something that you want to get right first time. Any unnecessary delays can be caused by improper or insufficient paperwork. Make sure your visa is done right first time. Give myself a call, my name is Mark, and I will help you look at the child visa and understand everything you need to know about making sure that your application is done right. Don't put your visa at risk. Failing to correctly apply for the child visa could result in it being rejected and having to start all over again and paying for all these costs all over again. Alternatively, you may have to apply to the Administrative Appeals Tribunal, which is a long and drawn out process. For more information about the Child Visa Subclass 802 or any other Australian visa, give us a call today. Contact and details are in the links in the description below. Mark Pelley here, Principal Registered Migration Agent from Visas to Australia. We look forward to talking to you real soon. Give us a call today.